Hello everybody and welcome to my tutorial on the law of attempts. So attempts sits in the criminal law unit area. It refers to a number of attempted crimes and how those attempts can be proven. An attempted crime is a preliminary offence. It's what we call an inchoate offence. So it's something that could be proven where you have tried but unsuccessfully been able to commit a full crime. Now, with any other criminal offence, there are two elements to proving an attempt. There is the actus reus of what an attempt could amount to, and also the necessary mens rea, depending on the attempted crime that you are accused of. So this sits within the category of what we call inchoate offences, which are a range of preliminary offences. So other inchoate offences are those crimes where a defendant could be accused of encouraging or assisting a crime to be committed, or even conspiring. So it's the lead up, it's the prior action and intention in trying to commit a full substantive crime, but as I say, being unable to for any potential reason. What do we need to look at? So we need to know what is meant by an attempt, and we'll have a look at what could amount to an attempt and why we have attempts initially. We'll need to know what the actus reus and the mens rea of proving an attempt are for your knowledge and understanding of this area of law under assessment objective 1. And then we will need to apply that law to given scenarios, and we'll have a look at how we may tackle answering an exam scenario. Let's just have a think about what could be an attempted crime. Now, I like to think of and visualise an attempt in terms of what could be the very last thing a defendant could do before committing the full offence. What's the absolute last act? And actually, the courts used to apply that. If you read about the history of how attempts developed up until the Criminal Attempts Act 1981, legislated by Parliament, there were a number of different case law tests. Now, if we were to evaluate this area, if we were to write an essay in this area, then I would cover more of the history with you. It's very interesting. There were 3 tests that the courts used to use intermittently, really, but we were only required through OCR to understand the law as it is in its present form and apply it. But I still think evidentially what can determine an attempt that helps me and will hopefully help you is to think about, well, what more could the defendant do in committing a crime? What's the last thing that they could do before actually committing the full crime? So if a defendant is trying the handle of a door, then is that enough potentially to make them guilty of an attempted burglary? What else would they be required to do? And, you know, the kind of what could amount to a full offence of burglary could be actually then going into the property. So this could potentially amount to an attempted burglary, with obviously the state of mind being able to be proven as well of the intention to commit theft, grievous bodily harm, or criminal damage in actual fact, as we'll come to upon entry. Knocking down a wall, could this be an attempted crime of some sort? Walking up behind somebody and taking your hands out of your pockets? Have a think about what these could actually amount to. Placing a ladder against a house. I mean, those 3 that I've just mentioned on their own are quite innocent actions. But if you couple those with a particular state of mind, then do we then have an attempted crime? Now, walking up behind somebody and taking your hands out of your pockets, if you are intending to permanently deprive them of property, if you're intending to pickpocket somebody or you're intending to mug them, is that then enough to amount to an attempted robbery? I mean, you can probably see from looking and thinking about these that an attempted crime can be really difficult to prove. And I think once we've gone through the law, what would be a good idea is to go back to this slide and apply the test and decide whether you think these would actually amount or evidence as an attempt. Taking out life insurance on its own is quite an innocent act. But what about if you have the intention to commit a fraud offence? Could that then be an attempted crime? Knocking on the door of somebody's house again, could that be an attempted burglary or assault? It really depends. And actually, on the note of assault, we'll look at what attempts, what you can be liable for in criminal law in terms of attempting. Not all crimes can be charged as an attempted crime. Okay. So why do we need to criminalise attempts? The rationale for this area of law is about prevention of harm and deterrence, really. The law of attempts enable the police to deter crime. So they have the power to arrest somebody if they believe that that person is about to commit a crime. And that power comes under the Police and Criminal Evidence Act, 1984. But the area of criminal attempts was legislated 3 years earlier, and I believe that that's part of the reason for this widening of powers of arrest in PACE. So this is all about detection and deterrence of crime. So it enables the police to identify those who pose a risk of danger and harm to society. It holds people accountable for acts which they would have carried out if they weren't stopped. And in criminal law, as you've already hopefully gathered, learning about the principles of criminal liability, the focus is largely on mens rea, the difference between intending to commit a crime versus realizing a risk and being reckless as to committing a crime. It makes a huge amount of difference. For killing somebody, it's the difference between murder and manslaughter, a mandatory life sentence with a significant tariff versus a discretionary life sentence with a significantly less period of time in custody. So the focus for attempts really as well is about, well, what did that person intend to do? If they weren't stopped, if they weren't able to commit the crime, obviously they'd formed the state of mind to commit it. So they should be liable for something. They should face criminal punishment. But of course, the difficulty is how you prove that. Where a crime hinges on its mens rea so largely as this does, it can be really difficult to prove. So I'm going to show you a screenshot, if you like, of the law in this area from the Criminal Attempts Act 1981. Okay, so this area of law codified by Parliament, and you see the law of attempts comes under Section 1. So if you look top left, Section 1 here, and then all of these down here are what we call subsections. Okay, so these are additional items and pieces of law underneath. So you could call these Section 1.1, 1.2, 1.3, 1.4 and 1.5. Now where you see that you might have subsections with a capital letter afterwards, here if you look under subsection 1, you've got 1A and 1B. These indicate additional pieces of law that have been inserted after the act was made. Okay, so these indicate newer updates. And where you've got your little F1, F2, F3, these will probably make links to other laws, so that in the legislation you'd find them as footnotes. And certainly online, we can make reference to footnotes really easily now. So what I want you to do is just pause this and have a look at if you can find what the law of attempts is. What does Parliament say that is required for the law of attempts? You need something from subsection 1, something from subsection 2, subsection 3, 4 and 5. And in actual fact, you could miss out subsection 3 if you wanted to, but certainly 1, 2, 4 and 5 are important, okay? All right, so having looked at that, what is the law? So you've got under subsection 1, a defendant has to commit an act which is more than merely preparatory. That's a bit of a mouthful. Make sure you can say that out loud to yourselves. More than merely preparatory. Sometimes to shorten it, I'll put MTMP to the commission of the offence. So we have to look at what have they done physically that is more than mere preparation in committing the full offence. Okay. Coupled with that, they need the mens rea, also under section 1.1, which is to intend to commit that offence. So they have to have the intention to commit the relevant offence. The mens rea has to be there. There is a slight limitation on murder, which we'll cover later. You can be guilty of attempting the impossible. So you could be guilty of an attempt even if you could never have committed the full crime due to the circumstances. Okay, and that's under subsection 2. So you've got subsection 1, subsection 2. And then hopefully you saw under 4 and 5, the law of attempts only applies to triable offences that are indictable. So if you had a triable either way offence that is so serious that it's tried in the Crown Court, then that could give rise to an attempted crime. But also under subsection 5, theft can also be an attempted crime too. So when I mentioned earlier about assault or battery, these will never be attempts, okay? So for the purposes of your OCR specification, you could be guilty or you could advise somebody on liability for an attempted murder, an attempted robbery, an attempted burglary, an attempted theft, and an attempted GBH or wounding, possibly a high-level ABH, okay? And those are the only crimes on the OCR spec that give rise to attempted provision. So I hope that is making sense so far. All right, so let's have a look then at the actus reus. What does Parliament mean by the defendant commits an act which is more than merely preparatory? So what I want you to do, and this will be a little bit time consuming, okay, this is the bulk of your work, is to have a look at some of the key case law in this area. I will upload you a sheet separately onto our classroom portal, but for others that watch this as well, I've put the cases on the next slide, okay? So I want you to have a look at these cases. These are the key cases that have decided what, how this test should be applied. Some have developed this test further. If you look down the left-hand side with the case names, Gulliver, third down, is a key case that has developed this further, and Geddes below it as well. So these are really interesting cases. And what I'd like you to identify on the right-hand side is whether the actions of the defendant in each case amount to more than merely preparatory. So do they commit an act which is more than merely preparatory to the commission of the full crime? So more than preparing or the preparation for a crime. If you don't think they have, then that will be pure preparation and that will not amount to an actus reus of an attempt. So please pause and have a go at that. Okay, so I'll take you through them. So White This was deemed to be an act of more than merely preparatory. So White was guilty of an attempt, despite him not being able to ever kill his mother fully. Arguably, this was attempting the impossible. His mother had already died. But he had committed an action which was more than merely preparatory by putting cyanide in her drink, and coupled with that, he had the mens rea, the intention to kill her. The Attorney General's reference case, so this was obviously a case led by the Attorney General, so an important case. Remember, they get involved to decide important points of law. So did this amount to more than merely preparatory? Hopefully you've said yes. So had he committed an act which was more than merely preparatory to the full commission of rape? Well, yes. I mean, he lowered his trousers, he interfered with the girl. It was only for the fact that his penis was flaccid that he couldn't commit the full crime. Okay, so he'd done enough. If you go back to what I said, picturing what's the very last act that somebody could do or could commit before the full offence. Well, there's nothing more that this defendant could have done before committing the full offence of rape. Hopefully you agree with that. So that for me evidences that he has gone beyond preparation and he's moved to actions which are more than preparation here. Geddes, let's go. Gulliver, nearly skipped that one. Now, Gulliver was deemed to have only been preparation, because the next step, what would have made this more than merely preparation, would have been him going to the bookies and trying to reclaim that money. Okay, so he hadn't done enough to satisfy the attempt to steal here. And we're going to look at Gulliver in a minute, because in Gulliver, the court, what they did was clarify a bit more what is meant by merely more than merely preparatory. And what they said was that a defendant has committed an act which is more than merely preparatory if they have embarked on the crime proper. Have they embarked on the crime? He didn't go to the stand to reclaim money. So he hadn't embarked on that crime. He'd taken preliminary steps. So he'd had the race declared void, but he hadn't quite taken that last step needed in order to satisfy the actus reus to attempt to steal. Now, Geddes is always one that creates a bit of confusion because, on the face of it, this appears to be an action which is more than merely preparatory to falsely imprison a pupil. But the court actually said this was preparation. And what they'd said is, the basis of this was that he'd made no contact or communication with any pupils in the school. So he was preparing, perhaps, by being in the block and being in possession of his false imprisonment toolkit, clearly. But he hadn't taken any further steps. Perhaps if somebody had walked in and he'd attempted, made physical attempts to try and imprison them, then that would have sufficed. So it just shows you the high level threshold of being criminally liable for an attempt here, how high that can be. And Geddes, in actual fact, built on Gulliver, if you see, some years later after Gulliver, in terms of what should be asked. Now, in Geddes, what the court said was, because he hadn't approached any of the students, he had not embarked on the crime proper. And they said what a court really needs to think about is, has the defendant moved from planning or preparation to execution or implementation? Have they done something that shows they are actually trying to commit the full offence? Or are they only getting ready? And that's the difference here. They felt that Geddes was getting ready. This was the Court of Appeal, felt that Geddes was only getting ready, planning, preparing, but hadn't moved to execution or implementation. So quite an interesting case there, one that could divide people, as the Court of Appeal so often do. The case of Campbell, this would be pure preparation, not enough for more than merely preparatory. And this came up in an exam question some years ago. So we'll have a look at that in a bit, and hopefully you can apply Campbell and reach the same outcome. And then Toasty at the end, this was deemed to be more than merely preparatory. Okay, the examining of the padlock, taking the metal cutting equipment was enough to deem to be more than merely preparatory to the commission of the full offence of burglary. Okay, so I hope that this has helped you to visualise, because of course if you're applying in a scenario you need to have some understanding of what could evidence somebody acting more than merely preparatory. So hopefully that's helped you. The best way I find of understanding is to look at case law and look at how the courts apply these tests. So let's just recap what the key law is. So the Criminal Attempts Act tells us that a defendant must have committed an act which is more than merely preparatory to the commission of the full offence. And then Gulliver develops that in 1990, which says that a defendant must have embarked on the crime proper. Okay, they must have embarked on the crime, or actually they are trying to commit the full offence. Okay, and that's what they mean by more than merely preparatory. So a bit more development, as we know the courts can often do, to interpret laws set by Parliament. So this is an extremely high threshold here to find somebody guilty, or at least the actus reus committed or clarified here. And then we had Geddes that clarified, as I mentioned previously, the Court of Appeal wants us to consider two further questions. Has a defendant moved from planning or preparation to execution and implementation? Have they done an act which is showing they are actually trying to commit the full offence, or have they only got so far as getting ready? Of course, in the case of Geddes, they decided that he hadn't moved from planning or preparation to execution of his plan or implementation of his plan. Okay, so that's the actus reus of an attempt. What is the defendant trying to do? What crime are they trying to commit? And have they embarked on the crime? So have they committed an act which is more than merely preparatory? In evidencing that, have they embarked on the crime? Have they moved from planning or preparation? Are they actually trying to commit the full offence? Okay. Okay, so mens rea. So a defendant must have the intention to create or commit the said act. It's worth noting for attempts that intention can be direct or indirect. So let's recap, because we've just looked at this, what the tests are. So Moen gives us the test for direct intention. So pause this and see if you can test yourselves on what these cases say. So Moen says for direct intention to be made out that the act or the consequence must be the defendant's main aim or purpose. And then your fallback, indirect or oblique intention test, Woolen or Nedrick says that death or serious injury must be a virtual certainty, and the defendant must appreciate that. So where we have a potential attempted murder, we can use these two tests here, okay? Remember that indirect intention will only be applicable to those attempted murders or grievous bodily harm offences. There is an authority which used, or rather used the indirect intention test, but of course we hadn't at that time had the clarity of the virtual certainty level that we had from Nedrick, and then later in Woolen. Okay, the defendants here who threw a victim from a balcony were seriously injured but didn't die. The defendants were found guilty of attempting to kill the victim based on indirect intention. Okay, but remember, in 1980, the virtual certainty test was not around. So this was about the degree of probability at that point. Okay, so to find somebody guilty of an attempt, you need first to establish the actus reus, and then the mens rea needs to be proven. And a defendant must have had that intention to create the full offence, okay? For murder and Section 18, grievous bodily harm, attempted crimes, then you can apply the indirect test. For all other crimes, the direct test applies as usual. Just note that for an attempted murder, you cannot be guilty of an attempted murder if you didn't intend to kill. So for normal murder, full murder offences, you can be guilty of murder if you intend to kill or cause serious harm, and that comes from the case of Vickers. But for an attempted murder, the mens rea is even higher threshold. You must have intended to kill. And that's directly or indirectly, of course. But intention to cause grievous bodily harm will not suffice for attempted murder. So just note that particular principle. For AA star, you could be tested on that in a scenario. Could be something similar to the leading case on this principle here, Whybrow, where there was only evidence that the defendant, Whybrow, had intended to cause serious harm. He didn't intend to kill. So he was not guilty, okay? His wife suffered serious injuries. She suffered burns and nervous shock from being electrocuted when she took a bath, and she's lucky she didn't die. But on the evidence, he only had intention to cause serious harm to her. He didn't intend to kill her, bizarrely. So, and the courts clarified that for attempted murder, he needed to have intended to kill, because the intention, they said, becomes the principal ingredient of the crime. Okay, so he wasn't guilty. So just make a note of that limitation, please. Make sure you're aware of that. All right, I'm going to talk to you for a couple of slides now about attempting the impossible. Okay, so we know that that is within the legislation under Section 1, subsection 2. And it has been applied through the courts. It hasn't always been applied correctly, and hopefully these cases that I've flashed up here look familiar to you from when we were learning about judicial precedent and how House of Lords, or as it is now currently Supreme Court, can overrule previous decisions where they believe they've been made in error. Now, Anderton and Ryan in 1985 was a significant case that was actually decided by the House of Lords in error, and it was based on the law of attempts. Anderton brought a video recorder believing it to be stolen when it was not, and the House of Lords held that this couldn't be an attempt to steal. Now, if we think about what attempting the impossible could mean, this type of scenario falls within this, surely. Surely it would fall that if he believes something to be stolen, the mens rea is there. And if he's buying it, then he's attempting to handle stolen goods, is he not? So this was a blatant error made by the House of Lords. Luckily for them, a similar case came back a year later. And this is the problem. If you create a precedent that then filters down through the courts that is wrong, you'll have a whole number of miscarriages of justice. So luckily, they were able to rectify their mistake with a case that came to them a year later that wasn't about handling stolen goods, but was about essentially dealing or harbouring controlled drugs. So this was handling or dealing with prohibited and controlled drugs. And in this case, Shivpuri, the defendant, believed that they were concealing controlled drugs in a suitcase. They were not. It was actually just a suitcase full of vegetable matter, like dried matter. So, if you were to apply the previous decision in Anderton and Ryan, well, they couldn't be guilty of an attempt. They believed something, but it wasn't actually as they believed. But luckily, the court overruled Anderton and Ryan, so removed that previous law and held that Shivpuri could be guilty of attempting to deal or harbour drugs based on their belief, even though their belief was wrong. Just shows you what an impact the mens rea has, the power of the mens rea in this area of law. So, attempts to do the impossible are criminal attempts. Shivpuri could never, in that particular instance, have attempted to deal controlled drugs. The defendant in Anderton and Ryan could never have attempted to handle stolen goods physically, because it wasn't a stolen good. Video recorders are a thing of the past, aren't they? But it's not a stolen good. But it doesn't matter. You can attempt the impossible. And that really comes from the Law Commission. Thanks to the Law Commission, our full-time government-funded body that's set up to reform the law, asked for that to be put in to the legislation. So hopefully that makes sense. There's a more recent example which will hopefully really cement this for you, attempting the impossible. This comes from Jones, the case of Jones in 2007. So Jones was convicted of attempting to commit offences under the Sexual Offences Act 2003. So what he'd done is he'd set up a profile online and believed that he was talking to a 12-year-old girl and was trying to meet up with her with the view to commit offences, prohibited sexual activity with a child, and under 13 as well, makes this even more serious. Who he was actually talking to was a police officer who covertly was posing as the 12-year-old girl. Which is kind of a common tactic to be carried out by these particular teams of police. So he argued he couldn't be guilty because he wasn't actually talking to a 12-year-old girl, so could never have committed these particular offences under the Sex Offences Act. And hopefully you're thinking, well, applying the law of attempting to commit the impossible, he could absolutely still be guilty. Despite it being impossible, he could still be liable. Okay, so that is the law. Let's have a look at the application then. So you see, you've got two principles there that I've just referred you to: attempting the impossible and the limitation on what's needed mens rea-wise for attempted murder. Those types of things, and spotting those in a scenario, always give rise to AA star. It shows that high level understanding. So just make a note of those somewhere, please. Let's have a look at a short application scenario here. Try to hide the bottom box if you can. So this comes from a previous exam paper years ago. It was one of the smaller style scenario questions. So Elsa decides to steal vodka from a shop. She has a gun in her pocket. Outside the shop, she pulls out the gun, but changes her mind and returns it to her pocket. And then it goes on that she still wants to steal vodka, so she enters the shop, but discovers the shop has no vodka. I mean, that second part could potentially be a burglary there, and the final part as well. But is she guilty of an attempted robbery? Now, does she commit an act which is more than merely preparatory to the commission of the full offence of robbery? So obviously she's outside the shop. She wants to steal. She has a gun. So arguably she's planning, isn't she? She's planning to go into the shop and use that gun to threaten force or use force in order to steal, which is our robbery offence that we will come to in due course. We'll learn about these offences in more detail. The problem is she changes her mind outside of the shop. So she has not embarked on the crime proper. Okay, she has not moved from planning and preparation to execution and implementation. So hopefully you'd agree with me that she has not done enough to have committed the actus reus of attempted robbery. And if you link back to your key cases, that fits nicely with the case of Campbell there. Okay, and obviously an examiner would be basing this scenario on that. So just watch out for those similar scenarios that fit with key cases. Does she have intention to commit the offence? Is the mens rea there? You should always go on to consider that, even if the actus reus isn't made out. It just makes your answer complete. She has intention, but then she changes her mind. So, that intention goes. There is no actus reus and mens rea applicable here. So I would say she's not guilty of attempted robbery. Never forget to conclude, gives you an extra mark at least. And also, you could add in some key cases and the legislation here as well. Some students like to do a short paragraph explaining the law, and then they go into application, which is fine. What I like, and I think is more sophisticated, is to state the law and apply it as you go along. So what I would have done here, if this was, my exam question that I'm answering, I would start by saying the law of attempts is found within the Criminal Attempts Act 1981 under Section 1. Under Section 1(1), Elsa must commit an act which is more than merely preparatory to the commission of the crime. This means, as held in Gulliver, that she must embark on the crime proper and move from planning and preparation to execution and implementation. And then I could put Geddes in brackets there. You can always put cases in brackets. You don't have to talk about the facts unless they are extremely relevant to the case, to the scenario rather. And then I would go on to apply, and I'd say Elsa originally is outside the shop with a gun. She's wanting to steal. So arguably she is deciding, she's planning to commit robbery. However, she changes her mind, so she is not embarked on the crime proper. The actus reus is not made out. Then I'd say she must have intention to commit the full offence. This intention must be direct, based on the principle from Moen. Her main aim or purpose must be to commit the robbery. And then I would apply and say she has no intention to commit this offence here because she changes her mind. So therefore, she is not guilty of attempted robbery. Okay. So I've got one reference to an act there. I talked about two cases. What you could also add in is the Campbell case as well, a similar fact. So that could be another case. And then I used Moen. So I've got 5 citations of law there in that one short paragraph. And, this would only be in a typical exam question for you. This would be 1 out of maybe 2 or 3 incidents, issues that you need to state and apply for. And you only really need to add in 5 or 6, either cases or legislation, to gain full marks for assessment objective 1. So we've already hit those with just one incident. Okay, so hopefully that filled you with some confidence. Let's have a look at a fuller exam question. So please just pause and have a read of this. Okay, so I'm going to take you through the answer now, and hopefully you've had a think about this. So there are 3 incidents you see. So with a typical exam question, you would have 3 incidents. For exams from next summer, you're going to have 20 marks. So you'll have an extra 5 minutes, if you like, to plan. I recommend always planning answers before you write them. So you identify what the 3 incidents are, and then kind of identify the key principles, and then you start writing. Do not ever just start writing. It's such a waste of time, even though you might think, well, that's the best use of time. It really isn't, I promise you. So the first one, I would be saying, obviously recognising Thomas has decided to steal the surfboard, but his actions are unlikely to be more than merely preparatory. he's put off by the dog when he's trying to approach. So he's not moved from planning and preparation to execution and implementation. He doesn't embark on the crime proper. He has intention to commit the full offence, but the actus reus is not there, so he wouldn't be guilty. The second one, where Thomas throws the rock at Mr. Smith, I would say he embarks on the crime. He does commit an act that is more than merely preparatory of attempted grievous bodily harm. That's what I believe this to be. The Mark scheme offers you the alternative of actual bodily harm if you don't think the injury would be serious, as serious as grievous bodily harm, rather. But obviously he throws a rock at him, and it's only by Mr. Smith bending down that he doesn't actually hit him. So he's clearly embarked on the crime. He's moved from planning and preparation to execution and implementation. He also has the intention to commit the offence. And, this could be Section 20 or Section 18. I would say probably based on Section 20, he's most likely got intention to cause at least some harm, or at least realises the risk. I'd say intention is there, to be honest with you. And I'd say he's guilty. Okay. And then the third one, when he tries to steal Jill's purse, despite nothing being inside, so he decides not to embark upon the full crime. I'd say this could be seen as an attempting the impossible, because nothing's there that he wants. So he was never probably able to commit the full crime. But he's committed an act which is more than merely preparatory, because he puts his hand inside her bag to steal. So I think he has embarked on the crime, and moved from planning and preparation. So Gulliver and Geddes are absolutely supported there as well. He has the mens rea because he intends to steal her purse. And just note, there's a bit of a grey area of law here, where for property offences, it has been discussed in court whether, if somebody intends to steal, so let's say they rummage in a bag, not sure what they're looking for, but anything that they think is worth stealing, or somebody breaks into a house, again, not sure what they specifically want to steal, but just for anything worth stealing, it's like an opportunistic type intention. That's what the courts call conditional intent, which would actually, based on a kind of related case of Esom from the 70s, would have made Thomas not guilty, because the courts say if a defendant is intending to steal anything that they can get their hands on, but nothing in particular, that's not going to suffice for an attempt. There has to be intention to permanently deprive somebody of a singular kind of item, a specified item. In this case, he has intention to steal her purse. It just turns out that there's nothing within there to steal. So in this case, he would be guilty, but I would just make a note of that. That is, absolutely AA star, and for the most part, probably beyond the spec, but it has arisen in occasional scenarios like this. So just have a look at Esom on eLaw Resources and make a note of the facts. Okay, so in addition, kind of with this 25 marker, probably doesn't look that much on here to you on the screen, but with the adding of the legislation and the key cases, this would, give you 25 marks. So you could have a go at writing that out if you like. There'll be plenty of opportunity. So I'll just leave you with this slide, okay, a summary for your assessment objective 1. So a summary of the law of attempts so that you've got it all there. The parts in red you need to fill out, and all of those bits that you need are in this tutorial, okay, so you can go back through and have a look at those if you need to. And that's all from me. I hope this has made sense and you've enjoyed it, and see you soon. Thanks.